Plessinger. I have primarily focused in my practice on intellectual property and advertising law. So that is what I'm talking about today. I'm going to teach you all of intellectual property in hopefully the next 15 minutes. And all right. So I want to start off by just saying that, you know, you guys can't possibly learn everything that you need to know. Obviously, you've gotten a lot of information in the last hour or so. I really just want you to be able to issue spot so that then you can go and take timely action on these various areas. And there's, you know, every business is different. Some of these may or may not be relevant to you, but just so that you can be on the lookout and then know kind of some of the major pitfalls that I see commonly in a lot of the early stage companies that I've worked with. So we're going to start off with patents, which is, of course, one of the biggest topics that entrepreneurs ask me about in the Silicon Valley area. Obviously, most of it's tech. I used a lot of different examples here because technology, you know, especially software patents are not as easy illustratively. But there's many different types of patents. And the idea is that they have to be useful inventions, okay? So they have to be novel, non-obvious, and useful. That means that it can't be, for example, just a simple improvement on an existing invention, if that would be maybe like the logical progression of that invention. So the threshold there is that it has to be novel and non-obvious. One of the important things, and there's also design patents, which those have to be novel, non-obvious, and ornamental. It's probably a little less common, but I have a lot of clients that are in more like fashion and those areas. The patents, once you have one issued, the standard utility patent lasts for 20 years. So particularly, you know, if you talk about the pharmaceutical industry, this is just a game changer. Nobody else can sell that invention without your licensing it to them for 20 years if you get a patent. So, I mean, you get that, you know, talk about cornering the market, right? So that's why patents can be super valuable for companies. You have a patent on something and nobody else can touch it. So the drug manufacturers, of course, are like the big ones these days that we talk about. You know, if you get a patent on, for example, there's some disputes right now over some of the COVID vaccine patents, and you know, some international negotiations that have gone on in the last couple of years about getting you know, generic drugs, for example, to areas of the world where they might not be able to afford the patented versions and all sorts of stuff. But overall, and that can be, you know, get into some moral issues there, but for most of our clients, you know, it is important, if you have an invention that's patentable, you really want to address it in a timely manner, because time's really important for patents. Business method patents, I don't have time to go into, but there are, you know, business method patents, which it's a high bar to achieve. So useful, concrete, and tangible result. So here's a couple of famous examples. The like one-click, these are a little outdated, but they're some of the most famous ones. The one-click shopping purchase. You have to be able to show that like the technology really results in something, in a tangible result. One of the things that I need to, as I referred to with the timing, that I need to flag is that once you start disclosing the patent publicly, there's a time clock that begins running. And if you let that run out, you're basically going to not be able to file the patent or get patent protection. So once it's disclosed to the public, and that can look like different things, but usually a confidential discussion with venture capitalists is not going to be public disclosure. But if you go to, say, a tech conference and you demo your product, a beta version of your product or something like that, that would absolutely be public disclosure. So what I recommend is that you talk to a patent attorney early on before you begin any type of a roadshow whatsoever. These take a long time to file as well. They can be very complicated. So I would get on that right away. The other thing is, if for the people that are working full time while starting a side, starting your business on the side or something like that, if you're working on any technology, any inventions that are related to your employer's scope of business, you're kind of in a danger zone, because most companies will have clauses that, and just because of the way the law works, that assumes that the default ownership is the employer if their employee is creating it. So you really want to make sure, if you are doing that side hustle, that you're not doing it on company time. It's always after hours. You're using your personal computer. You don't ever use your company issued computer. And really, if it is something that, as I said, is like a competitive product or would be potentially in the product roadmap of your company, like there's a good chance that they're going to have rights to it. So that's something that you're going to want to probably disclose to them, have a conversation about. Just be careful about that. So trademarks nowadays with social media, I think that the whole, idea of brand is very much in the, the forefront of public consciousness. Like everybody is aware of people building their brands and influencers building their brands. And one of the cores of a commercial brand, for a corporate entity, is going to be the trademarks. So these are all trademarks. I noticed that there's no company names on here, but you probably know the company from each of these images or taglines. You see the Coke bottle, the Burberry fabric umbrella, the Apple logo, the Android logo, Yahoo, the shoes are by Louboutin. So anyway, all of these are very famous marks. And just by seeing that logo or tagline, we immediately in our mind make that association with the company. So that's a really strong branding right there, right? That's one of the first things that you want to establish when you're doing that marketing component, where you're moving into the marketing of your product. You can get a trademark in a logo. You can get a trademark in a name. Obviously, names of companies are generally trademarked. Names of products, and some more obscure trademarks are patterns, colors, and shapes. So anything can be trademarked, and I don't have time to go into these. Anything can be trademarked as long as it is essentially an indicia of that identity of the brand. So if you see it or hear it in some cases, you can think of like the Intel bong 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 sound, the MGM lion. There's some sounds that are trademarked, and as soon as you experience that, whatever that is, you think of the company, or you're aware that it is associated with the company. So at the core, trademarks protect consumers because they know where their products are coming from. So you might be one of those people that buys generic Coca-Cola, but there are some people that would never drink generic Coca-Cola, like the cola brand from a grocery store. They want to drink the Pepsi, they want to drink the cola, the Coca-Cola. To a lot of people, it really matters. That if you buy Nike shoes, you get a certain quality level. If you buy Gucci, you're getting a certain quality level. So at the heart, from the government's perspective, it's a consumer protection issue. But for companies, of course, it's marketing, and building that brand is super powerful in the mind of the consumer. So copyright these days, most of what I see with the average, startup for copyright, this is going to come in during your advertising. So a lot of the rest of this presentation will talk about advertising. And nowadays, of course, social media is where a lot of people are advertising. But copyright covers anything that's a creative work. So it can be a photograph, it can be a painting, it can be a novel, and songs, and even some, because they are essentially written works, some software can be copyrighted. The protection you get in it is very different than you get from a software patent. So it protects the creative elements, the elements of expression, and not so much the utility of it, right? Newspaper articles as well. Infringement is going to be based on substantial similarity. So it doesn't have to be exact to be infringing. So a lot of the stuff that you see in social media these days is technically a copyright infringement. Now, if it's done by a person, memes, for example, like all memes are pretty much in most cases copyright infringement. If I make a meme and I post it on my personal social media channels, no one's likely to come after me. But as a company, since you're a commercial venture, you presumably have some money and you should be a little bit more buttoned up than the average human being. This does matter. So a couple of famous examples here also from the Obama campaign. There was a campaign poster that was done, and it wasn't an official campaign poster that was done. It was a poster that was done around the time of the campaign based on this photo that was owned by the Associated Press. So the Associated Press took the photo of Obama. They owned the copyright. This artist, Shepard Fairey, painted this, has become an iconic poster, but they never got the license from the Associated Press to create this poster and then sell it. And Shepard Fairey made quite a lot of money on this poster during the Obama campaign and got sued by the Associated Press. With artists, sometimes there's a fair use argument. We don't have time to go into that, but let's just say as a company, as a commercial company, you're pretty much never going to be able to use a fair use defense. So just don't even bring it up. Not an option for you. I think we'll go on. Right of publicity, which I'm going to tie in with copyright a bit because they tend to really be related in the area of advertising, is going to cover the rights of not just celebrities, but celebrities are often the most common that we think of when we talk about right of publicity. I don't know. I don't think I have time for the video, but this is a commercial that was done with a Kim Kardashian lookalike. And the brand basically couldn't afford Kim Kardashian. And so they got a lookalike to appear in their ad, and they were promptly sued by Kim's people because it was just super obvious that what they're trying to do. And so right of publicity is the right of all of us, even us people that are absolutely not famous, nobody really cares, but to control our likeness. That includes, our face, our appearance, our voice, anything that could be, especially for people, say like a famous actor where their voice without seeing their face, like anything that's going to be a personally identifiable aspect of them. They say, their likeness, their name, anything that's you're gonna be like, oh, well, that's that person. So you want to be really careful using any celebrities in particular, but any person in your social media. One kind of, I like this example because it's really mundane. Like so many of the famous right of publicity cases are like huge stars that some company used in a commercial, or used a photo of them that they hadn't authorized, something like that. But this situation with LinkedIn is so just like kind of common that I think we see these things and we're getting so used to it in marketing that probably not that many people questioned it. But basically what happened, this is back in maybe about 10 years ago, when you sign up for LinkedIn, through that sign up flow, they give you the option at some point to essentially have it go through the rest of your contacts, right? And it can send invitations to people in your contacts that are not already on LinkedIn. They don't already have LinkedIn profiles. And what it does is it comes as in a way that looks like you're personally inviting them, right? LinkedIn in this situation, they did get consent to send that first email. They did give some level of notification. It wasn't full disclosure though, because what they did is they sent a bunch of follow-up emails. So whoever in your contacts, say 50 of your contacts would get multiple emails, and it looks like you were sending them multiple invitations, right? So it has your name, it usually has your profile photo that you have on LinkedIn, and it looks like you're inviting them. And so this is a right of publicity violation. Like, we all have the ability to protect our name, our likeness, any indicia of who we are. And so LinkedIn had to send out settlement checks to a whole class of people that had subscribed at that time for violating their publicity rights. Going back to copyright, but also, adding in the publicity here, I'm seeing a lot, and I'm picking on this one little company. They sell like coffee that has adaptogenic mushrooms in it. It's not hallucinogenic, but they really like to kind of play that up in their advertising. But I see tons of copyright infringement and right of publicity infringement on Instagram these days in usually smaller companies' ads. So these are a few examples. They're using Britney Spears, the Saturday Night Live skit, and even Joe Biden to advertise their coffee or their mushroom products. And presumably they do not have the budget to get any of these people, let alone all of them. So, the risk, I would say here, it can be in the practical world, like this is blatant infringement. In the practical world, are they going to get caught? I don't know. It depends on whether one of Britney's people sees this and flags it to her. But you very well could get a very nasty letter from Britney's attorneys and ask you to take it down or pay some kind of settlement. So it's generally not the kind of headache that you want. These are probably also, once again, the actual media, the videos that were featured here. And again, I didn't add the whole video, but the videos themselves were also subject to copyright. So there's two levels of violation here, the copyright holder, as well as the right of publicity. And again, I see this every single day in social media from small companies. So I'm just gonna advise you not to do that. It should be licensed if you want to use anybody's likeness, whether they're just a starting out actor, or they just is trying to get work, or whether they're a famous celebrity and you wanna make a meme out of them. You need to license it. Even Virgin America, or I think it was Virgin out of Australia, actually had grabbed a photo of this girl off of one of the, maybe Flickr or something like that, one of the photo sites. They thought that they could use it because these photo sites are so commonly used by companies to grab their media. They had not paid for it. It was what they thought was basically like an open license for use, but it didn't cover, the license didn't cover the right of publicity of the individual. So once they put it on a billboard, then it became problematic. If they had just used, if somebody just used it for personal use, it would have been fine, but they were sued. They had to take down billboards all over the country and pay the girl. I can't remember what the amount was, or maybe it wasn't disclosed, but they had to pay a large settlement for violating her right of publicity. And I know I'm way over, so just gonna say on trade secrets. Trade secrets, if you can't get a patent on something, trade secrets are a great way to keep something confidential, really protect it and have that competitive edge. So a lot of famous, things in tech are actually trade secrets. The Google algorithm is a trade secret. The Facebook newsfeed algorithms have been trade secrets because they don't qualify for patent protection. McDonald's secret sauce, the KFC recipes don't qualify for patent protection or any other kind of intellectual property protection. So trade secrets are a great way to continue to protect your the uniqueness of your product without actually having to file anything or get that formal protection. You essentially just have to keep it confidential, and there are some parameters around what that looks like. You don't disclose, if it's a recipe, you don't disclose it to anyone, you don't share it with anyone, you don't leave the recipe on the copy machine laying out. It's really kind of on a lockdown. Only those employees that need to know have access to it. So I think that's about as quickly as I could go. And yeah, I'm just going to wrap up there. Thank you.